have no further questions, Your Honor.
Counselor, your witness.
Thank you, Your Honor. Mr. Morrison, you just told your attorney on direct examination that when you first saw the traffic light at the intersection where the accident occurred, the light was green when you first saw it, and then it proceeded to turn yellow as you went through the intersection. Do you remember that?
Yes, yes.
Well, sir, do you remember giving a deposition in this case in my office approximately 8 months ago?
Yes, I remember.
And do you remember being asked the following questions and giving the following answers? Mr. Morrison, what color was the traffic light when you first saw it? And what color was the light when you proceeded through the intersection? And you answered, well, the light had just turned to yellow when I first saw it, and when I went through the intersection, it turned to red. Do you recall being asked that question at your deposition and giving that answer?
Yes, I remember.
Well, sir, you just testified that the light was green when you first saw it, and it turned to yellow as you went through the intersection on direct examination. Do you remember that?
Yes.
Well, sir, you just told your attorney on direct examination that the light was green when you first saw it, and then had changed to yellow as you went through the intersection. And 8 months ago at your deposition, you testified that the light was yellow when you first saw it, and then changed to red as you proceeded through the intersection. Do you remember that?
Yes, I remember.
Well, the light could only be yellow when you first saw it, or green when you first saw it, correct?
Correct.
Mr. Morrison, did you take an oath to tell the truth before you took the witness stand this afternoon?
Yes, I did.
And you took an oath to tell the truth at your deposition 8 months ago in my office, correct?
Correct.
So, sir, what I'm asking you here today is, what version of the story is the truth? The version of the story that you gave 8 months ago in your deposition, or the version of the story that you're giving us here today in court?
I don't know.
Well, sir, if that light was red as you proceeded through the intersection, isn't it possible that the light was green for the plaintiff as he proceeded through the intersection?
Yes, it's possible. It's possible.
Nothing further, Your Honor. Hello, my name is Glen Kurtis. I'm a New York licensed attorney practicing in the areas of commercial law and personal injury litigation. I developed this video to help you understand and become comfortable with the next phase of your case, the deposition. By the end of this video, you'll have a clear understanding of what a deposition is, how important it is, and what to do when faced with particular situations during the actual deposition. You just saw how critical the deposition can be during the course of a trial, but it's also an important fact-gathering tool, not only for your opponent, but for your attorney as well. It's rare that I don't find out a few facts about my client, their case, or the opponent during the course of a deposition that I didn't already otherwise know. So let's take a look and see how those all-important questions and answers came about. First, what is a deposition? A deposition, or sometimes called an EBT, short for examination before trial, is when the adversary or opposing attorney has the opportunity to ask questions of a witness or party in a legal action. The questions and answers are on the record or recorded by a certified court stenographer. The attorneys in the case are then given copies of the transcript of the deposition to help them understand the facts of the case, to prepare for the trial, and as you saw earlier, to cross-examine a witness on the witness stand. The length of the deposition can last anywhere from half an hour or less to literally days in complex cases. By the phase of the case where you're preparing and appearing for your deposition, your attorney and the opposing attorney or adversary have probably met several times in court and spoken on the telephone numerous times. It's fair to say that the attorneys have developed some sort of relationship, whether purely adversarial or friendly and courteous. The deposition will most likely be your first and only chance to meet and be in contact with the adversary prior to trial. It will serve not only as a tool to evaluate your case, but to evaluate you as well, your demeanor, your type of personality, and your knowledge of the facts that led up to the action being filed, and of as your attorney as an advocate. It will also be used by the other side to try to determine what type of witness you'll be on the witness stand should the case go to trial. You may come across as strong, weak, evasive, candid, etc. The deposition is also an important factor in resolving your case for those reasons. Let me identify the likely players who will be involved in your deposition. The stenographer or court reporter. He or she will be there not only to record what is said, but also to read questions and responses back to the parties where they were not heard or understood, and to mark exhibits that might be used during the questioning. We'll take a look at both of those instances a little later. A few weeks after the deposition is over, you'll receive a copy of the transcript from your attorney. You'll have the opportunity to make corrections in the transcript that the stenographer may have transcribed incorrectly. The adversary or opposing attorney will be there. That's the attorney who will be asking the questions. Almost everything said to a witness by the adversary will be done on the record and recorded by the stenographer. It's generally not proper for an adversary to speak to a party in the action without their lawyer present. So don't feel that the attorney is being rude by merely saying hello and doesn't engage in small talk while you're waiting for the other parties to arrive. Your attorney will be present. They'll discuss the deposition further with you and prepare you for specific types of questions that may be asked by the adversary. They will also make objections to improper questions and advise you on what to do. We'll take a look at this a little later as well. You, the witness, of course, will also be there. Remember, not only will a deposition be used to evaluate the facts of the case, but also you as a witness. Your dress should be at least business casual. There's no specific need to wear a suit and tie, but bear in mind you might be sitting for a few hours, so keep your own comfort in mind. There are also subtle elements that the adversary may use to evaluate you before the deposition even starts. Are you on time? How are you dressed? Do you appear nervous, frazzled, or uncomfortable in being asked questions? Do you look the attorney in the eye when answering? And most of all, are you a believable witness? In most states, all parties to the lawsuit have the right to be present with their own attorneys at any deposition in the case. Witnesses who are not parties to the action are generally excludable from the deposition room. If you want to have somebody there just for support who is not planning to testify at the trial, perhaps a parent, spouse, sibling, or friend, it may be allowable. Request that your attorney get permission from the adversary for these people to be present prior to the deposition date. The only other party that may be present during the deposition is a translator. They, like the court reporter, must be certified. A friend or family member usually will not be permitted to act as a translator for the deposition. The important thing to remember when using a translator during the deposition is to wait fully for the translator to translate the entire question before answering, even if you understand most of the question in English. Also, remember to answer in your native language, even if you feel you can do so in English. Before the deposition starts, the attorneys will usually agree on a set of rules or stipulations on the record. This basically sets the ground rules for the permissible conduct during the deposition. In some instances, a judge or judicial hearing officer may be available by telephone during the deposition for rulings on the conduct and questions during the deposition. Another important preliminary step in the deposition is the swearing in of the witness. Generally, the court reporter will ask you to raise your right hand while he or she asks, "Do you solemnly swear or affirm that the answers you will give during the course of this deposition will be the truth, the whole truth, and nothing but the truth, so help you God," or something very similar? A simple yes or I do will suffice. Some people, for religious reasons, will not swear to tell the truth, and they may state that they affirm to tell the truth instead. This is just as valid. Be sure to tell your attorney or the court reporter that you prefer to affirm the truth of your answers rather than swear to them. Of course, all answers must be stated orally. A court reporter cannot note for the record that the witness is nodding or shaking her head. So when a simple yes or no answer applies, remember to state it through words and not actions. Once the swearing in has taken place, the adversary will introduce him or herself on the record and may give some additional instructions. They'll tell you to simply ask for a break if you need one, to use the bathroom or get a drink of water. They may also inform you to answer the questions that you understand, and that if you don't understand a question, to have it rephrased. Also, they will usually state that if an answer is given to a particular question, the attorney will assume that you understood the question in the form that it was asked. You're also entitled to take a break to consult with your attorney during the deposition. This can and should take place out of the presence of all other parties in the deposition room. The only exception to this is that you won't be able to take a break and consult with your attorney after a question has been asked and before an answer is given. You shouldn't be hesitant about taking a break for any reason. Oftentimes, a witness may break down during the deposition and start to cry. Only the most callous of lawyers wouldn't allow you to take a break at this point, should this happen. Something else to correct immediately is the pronunciation and use of the correct title of your name. If your name is a bit tricky or hard to pronounce, be sure to tell the attorney before the deposition starts. If the attorney later learns that they mispronounced your name for a few hours, not only will it be embarrassing for both of you, but it certainly makes a statement about your strength and character. Also, be sure to tell the questioning attorney your title, whether it be Mr., Mrs., Doctor, Officer, or some other designation. Let's take a look at the beginning stages of a typical deposition. You ready to begin, Counselor?
Sure, why don't you put the usual stipulations on the record?
It is stipulated between the parties that the civil practice laws and rules will govern the conduct during this deposition. It is further stipulated that the right to object or move to strike any testimony that's given at this deposition is reserved for trial. It's also stipulated that the filing of the transcript of this deposition with the court is waived.
So stipulated.
Can you swear the witness in, please?
Sir, can you please raise your right hand? Do you swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Please state your name for the record.
Alex Morrison.
Good morning, Mr. Morrison. My name is Glen Kurtis. I'm here today to ask you a series of questions regarding an auto accident that you had in June of 2005. If at any time you don't understand my questions, please let me know and I'll try to rephrase them. If at any time you wish to speak to your attorney or take a break to stretch your legs or use the bathroom, please let me know and I'm sure we can accommodate you. I'd also like to remind you to keep your answers verbal in nature so the court reporter can take everything down, okay?
Yes, yes.
The first section of the deposition will be devoted to general background information, or sometimes called pedigree information. This section will include questions regarding your age, date, and place of birth, your current and prior addresses, years lived at those addresses, medical conditions, current medications, criminal convictions, employment history, among other areas. As in every area of the deposition, truthful answers are paramount. You may not think that these types of questions are relevant to your case, but they may be. The deposition is first and foremost a learning tool. The opposing party wants to learn as much as possible about you, your past, and your case. If there's something that can be uncovered and used against you later or at trial, the opposing attorney will try to find it out. You should avoid guessing about any answers. If you don't know something or don't remember a fact, simply answer the question that way. We'll continue with Mr. Morrison's deposition from his auto accident case. Mr. Morrison, what's your address?
1022 East 56th Street, Brooklyn, New York.
And what's your date of birth?
12256.
And your social security number?
102-73-7008.
And where were you born?
Jamaica.
And when did you come to the United States?
In 1987,
And what's your status here in this country?
I'm a U.S. citizen.
And how long have you lived on 56th Street?
I've lived there for 8 years.
And did you live there back on June 3rd of 2005?
Yes.
And who do you live with?
I live with my wife and my daughter.
And do you own or rent that apartment?
No, I rent.
Are you currently employed?
Yes, I'm a cab driver.
And who are you employed for?
I own my own medallion and cab.
And how long have you had the medallion that you're driving under now?
Since November of 2003.
How long have you been driving under your own cab and medallion? Did you start driving under that medallion in 2003?
Yeah, right after I got the medallion, yeah.
And what were you doing before that, before November of 2003?
I was driving for a company on 51st Street called SNK Transport.
And how long were you driving for SNK Transport?
I drove for them since 1990.
In June of 2005, did you have a valid driver's license?
Yes, sir.
And what class of license was that?
It was an E-class.
Is that a hack or a TLC license?
Taxi license, yes.
The license that you had in June of 2005, was that New York State license?
Yes, it was a New York State license.
How long have you had that license?
Since 1990.
Does that license have any restrictions on it, require you to wear glasses or corrective lenses or anything like that?
No.
On June of 2003, were you being treated by any physicians for any medical conditions that you had?
No.
The second section of the deposition will focus on the event that led up to the filing of the lawsuit. Generally, in an accident case, it will start with everything you did on the day of the accident, usually from the time you woke up in the morning to the time of the actual accident. Where were you going? Who were you with? Were you running late for an appointment? And all the details of the accident. In other actions, the questioning will be tailored to the specific type of case: the breach of contract, property damages, the grounds for the divorce, etc. This is the most important area of the deposition. It will hopefully form the framework to win the case or have the case dismissed if you're the defendant. Of course, your attorney will prepare you about the specific questions that will probably be asked during this phase of the deposition. From time to time during the deposition, you may hear your attorney object to a question. The most important thing to remember as a witness is to stop talking immediately. After the objection is raised, the attorneys will usually discuss the basis for the objection, and your attorney will advise you to answer or not answer the question, or to answer the question only to a certain extent or time frame. If a ruling is required, the attorneys may place a call to the judge assigned to the case for guidance or a decision on an issue. The worst thing a witness can do is answer a highly prejudicial question after an objection has been raised and before the objection has been discussed with the attorneys. At that point, it's almost impossible to have the opposing attorney ignore the question and answer. An objection can be made for any number of reasons. The question can be poorly stated, too prejudicial, or completely irrelevant. It may also relate to a matter that is privileged. That means that it's protected by law and should not be disclosed or discussed at the deposition. Some privileged discussions may occur between an attorney and their client, between a husband and their wife, or between a clergyman and a parishioner. Just remember that when an objection is made, don't answer or continue your answer until you are advised to do so by your attorney. Another common occurrence at a deposition is a non-responsive answer. A non-responsive answer is an answer that doesn't address the question that's being asked of the witness. If this occurs, the questioning attorney will usually ask the question again or have the question read back by the court reporter. The thing to remember here is simply try to answer the question that is asked without adding any unnecessary information. Most cases will involve some sort of documentation. This also may be presented to you at the deposition and asked about. The questioning attorney will have the document marked so it can be identified on the record by the court reporter, and then it will be presented to the witness to review. Take your time looking at the document or photograph to be sure that it is what it claims to be. If you can't identify the document, simply say so when asked, and most likely there will be no further questions based on that document. If you need a question read back by the reporter, you can ask to have that done. Also, you can ask to have any question rephrased or re-asked by the attorney if it is confusing or you don't understand it. The next segment is from a deposition in a slip and fall case. If you're a defendant in the action, the deposition will end with questions about the incident, accident, or occurrence at issue. Of course, the questioning in your case will be different from the example shown on this video. I just wanted you to become familiar with the types of questions that will be asked, as well as the depth of the details that you will be asked to recall. For a plaintiff, the deposition will continue on to the third section.
Would you mark these, please? Were you involved in an accident on January 16, 2005?
Yes, it was a Saturday, January 16th.
At that time, were you under the care of a physician for any reason?
Not really, just like my normal yearly checkups.
What was the name of the physician, your regular physician that you would go to for checkups around that time?
Dr. Susan Anderson in White Plains.
When was the last time before January 16, 2005 you saw Dr. Anderson?
It was October 2004. I saw her for hypertension.
Were you taking medications for hypertension?
Yes.
What medications were you taking?
I can't remember.
I'm going to ask that the reporter put a space in the record And when you get the transcript back from your attorney, if you were able to determine the name of the medication you were on, you can write it into the transcript. Is that okay?
That's fine.
Yes, I have the prescription at home.
Did that medication have any side effects that you were aware of or that you reported to your physician?
No,
Prior to this accident, did you ever injure your ankle?
never, no.
At the time of the accident, where were you living?
At 28 Hillcrest Avenue, Elmsford, New York?
Do you live alone?
Yes, but sometimes my boyfriend would stay with me, but he wasn't there at the time of the accident.
How often would your boyfriend stay with you?
I'm going to object, Counselor. I think that's completely irrelevant to any issues that could possibly arise in this case. Why don't you move on to your next question?
Were you living under a lease at the time of the accident happened?
Yes,
Who were you leasing the property from?
it was Anna and Joseph Laurent.
While you were living at that location, did you have a specified parking space that you would park in?
Yes,
Where was that?
that was in the driveway next to the house. I had an assigned space there. I was told to park there by the landlords.
Can you describe the driveway?
Well, it's a long driveway with a bit of an incline right next to the garage of the house.
On January 16, 2005, did you park in that spot in the driveway?
Yes, I did.
Where had you come from when you parked your car just before the accident happened?
I was shopping, grocery shopping.
How many bags did you have with you when you got home that day?
One little bag with 2 items in it.
What were the items?
Onions, about 3 or 4 onions, and a can of tomato paste.
Were you by yourself?
Yes.
And what were you wearing that day?
Well, I was wearing my turquoise sweatsuit, my winter clothes. I had a jacket on, and I had my heavy winter sneakers on that I always wear. They had thick soles.
What was the make of those sneakers?
I forget.
Where did you get them?
I don't remember where I got them.
Do you wear glasses, ma'am?
No.
Besides the bag with the onions and the tomato paste, were you carrying anything else?
My pocketbook over the shoulder.
Which shoulder did you have your pocketbook over?
It was right side.
What time of the day did the accident happen?
It was early in the morning at around 9:30, 10 o'clock. It was around that time period.
Was it sunny out, cloudy, precipitating in any way?
It's a beautiful, clear, sunny day.
When was the last time before the accident date that it had snowed?
It's probably about 3 days. The heavy snowstorm with ice. I remember everything was closed.
What was the temperature the day of the accident? Do you remember?
No.
Was it very cold?
Yes.
When you walked down the driveway from your car, did you have to walk downhill slightly?
Well, yeah, it goes down slightly.
When you went to your car to leave the apartment on the day of the accident, did you have any trouble getting to your car?
Yes, it was slippery. I was cautious. It wasn't cleaned properly, the snow and ice.
Where was the snow and ice? Was it all over the driveway or only in certain parts?
It was actually all over the driveway. Some places was less, some places more. You couldn't see the clear driveway.
Did you observe ice patches or just snow on the ground?
It was ice patches.
Describe these ice patches for me if you could. What were their dimensions? How big were they?
Different sizes. There were big ones, small ones.
The biggest one you saw, how big was it? Was it an oval? Was it a circle? Something else?
It was, yeah, the one on one side, it was still a big patch.
How big is a big patch? I don't know what a big patch is.
I mean, I'm not exactly sure.
Was it bigger than the distance between you and me?
I just did not pay it. The driveway was covered with ice patches and old snow. I walked there all the time, all winter. It was never cleared unless the sun cleared the ice. It was just never taken care of.
I'm going to move to strike those portions of the answer that are not responsive. Ma'am, this is what I'm going to ask you. The largest patch of ice that you saw when you were walking up to your car to go that morning to the grocery store, can you tell me how big it was? That's all I want to know.
Can you read that question back, please?
Question. Ma'am, this is what I'm going to ask you. The largest patch of ice that you saw, can you tell me how big it was? That's all I want to know.
There were patches maybe 2 feet long by 3 feet wide. I really didn't pay attention. I just know there was a lot of ice. The driveway just looked bad. You had to be careful.
When that snowstorm occurred approximately 3 days before the accident, from that point forward until the day of the accident, did you personally ever tell the landlords about the condition of the driveway?
Yes,
When was that?
right after the snowstorm when I went to work. It was still in bad condition. I got the salt. I put the salt on. I shoveled myself.
How much salt did you throw down after the snowstorm?
Half a bag.
And did that work? Did that help?
Yes, it melted. You know, in time it melted some.
Did you attempt to throw more salt down on spots that you noticed didn't melt?
Not at the time.
Did the landlords come with the plow to plow out the driveway the morning after the storm?
I did not see that. When I came back from work, the day after the storm, the driveway was plowed. The heavy snow was gone.
And it was after that that you threw the salt down?
After that, yes.
When you got out of your car after you got back from the grocery store, was there anything obstructing your view of the ground?
No.
And when you got out of your car, how many steps did you take before you fell?
I don't know. I mean, maybe 5 or 6.
Where were you looking when you were walking?
I was looking down.
Did one or both of your feet slip on the ice on the driveway when you fell?
One, my left foot.
Was your right foot on firm ground when you slipped?
Yes.
And did you see any ice underneath your left foot when you stepped down?
Yes, I saw ice.
Did your left foot slip out from under you in front, to the side, to the back?
It slipped out to the left, and then it turned back. I felt it turn my whole foot back to the left, and I heard a crack when my foot twisted.
And then you fell down?
Yes.
Did you fall down to your right side, to your left side, to your front or your back?
Straight back on my head, just straight back.
Did you hit your head on the ground?
Yes.
Did you lose consciousness as a result of falling?
I know I fell back, had my eyes closed, and I hit my head, and I saw like just one instant, like stars, like black. I mean, I never lost consciousness, so to speak, but it was like black for a second, like stars.
And there's no memory loss of any events surrounding the fall, correct?
No.
How long did you lay on the ground before help arrived?
I mean, I couldn't get up. I started to scream, help, help. I must have screamed like 100 times. I need help. Somebody hear me.
Do you know how long it was that you were screaming for help before someone came?
It seemed long, but it was maybe 10 minutes.
Who came to assist you?
I saw a little boy and a man in back of him that walked up to me.
Did you recognize the man?
No.
Did he ever say who he was?
He said he was a neighbor, and he said to his wife, they were in the living room, they heard me scream. His wife said, go out and help. The lady fell down. They saw me just lying there. That's what he said, and he came running out, and the little boy, and the man said, go get the cell phone, get the phone, we have to call 911. And the man, he stayed with me, and then they called 911.
Did an ambulance ever come?
Yes.
How long was it after you fell that the ambulance came?
From the time the man saw me and called the ambulance, it came very fast.
Did the ambulance take you to a hospital?
Yes.
Ma'am, I'm going to show you what has been marked as Defendant's Exhibits A through C for identification. I'm just going to ask that you take a look at these 3 photographs, and then I'm going to ask you some questions. When you're done looking at them, let me know, okay? Don't say anything until you're done looking at them, and then let me know when you're finished. Do you recognize what's depicted in these 3 photographs, ma'am?
Yes, I recognize the pictures.
What are they pictures of?
They're pictures of the defendant's house.
I'm going to show you what's been marked as Defendant's Exhibit C. You see that photograph?
Yes.
Does that photograph show the driveway where the accident happened?
Yes.
Is the driveway and the house and the lawn, the trees, everything the same as it was at the time of the accident?
Absolutely, yes.
In that photograph, Defendant's Exhibit C, there's a person standing in the driveway, correct?
Yes.
Is that person standing in the general area where you fell?
I fell just a little more down.
More towards the bottom of the photograph?
Yeah, like here.
I'm going to give you my pen, ma'am, and I want you to take my pen and draw a circle in the area where you fell. Where you fell, not where your car was, but where you fell. Just draw a circle on the photo.
I would say it's about here.
And that's fine. You marked it with blue ink, correct?
Yes.
Do you see the car that's in the photograph, Defendant's Exhibit C?
Yes.
Is that approximately where you parked your car?
Yes. Well, but I parked a little to the left.
And over that course of driveway between where you got out of your car to the point where you fell, were there any icy patches other than the one where you fell?
Yes, there were.
And did you step over those or go around them or avoid them in any way?
I tried to avoid them.
The area where you marked in Defendant's Exhibit C that you fell, where you circled that little area, was that one of those areas that you threw salt on?
Yes. Can we take a break? I'd like to discuss a few things with my attorney.
In this section of the deposition, the attorney will be asking about everything that happened as a result of the incident, accident, or occurrence in question. The attorney will take you from the moment the accident or occurrence took place up until the day of the deposition. It will contain the injury or damages that were sustained as a result of the defendant's actions. In a personal injury case, you'll have an opportunity to explain the medical treatment you received, the doctors you saw, and the therapy you needed. You may still be under a doctor's care on the date of the deposition. You will testify about your current medical care and the treatment you may need in the future. You will be asked about the expenses you paid out of your own pocket and what bills were covered by insurance or other third party. In other cases, you'll be asked about any financial or other losses that you suffered as a result of the accident. If it's possible to show proof of any of these losses you suffered, such as receipts, bills, canceled checks, or credit card statements, by all means bring that proof with you and review it with your attorney prior to the start of the deposition. We'll continue with the slip and fall case.
Let me go back to the day of the accident. The ambulance comes and you're taken by ambulance in a stretcher to the hospital.
Yes.
What hospital did you go to?
This is Westchester Medical Center.
Were you admitted to the hospital?
Yes.
For how long?
A week in the hospital, in the medical center, and a week for physical therapy and rehabilitation at Taylor Rehab.
What doctor did you treat with at the hospital?
Dr. Marshall.
Anybody else?
Well, there was assistants and nurses. I don't know their names.
Did anybody explain to you what was wrong with you when you went to the hospital?
Oh, yeah, Dr. Marshall.
What did he tell you?
He told me that in a medical term, I can't remember the name, and he said that I have a broken ankle. That was kind of difficult because the ankle had jumped out of the socket at the time of the accident.
Did you undergo surgery in the hospital?
Yes,
What was that for?
for my broken ankle.
Did Dr. Marshall tell you why he was doing surgery?
Absolutely. He said we have to put screws in and a plate because of where the break in the ankle was.
Was a cast put on your ankle after the surgery?
Yes, immediately after the surgery.
Did you have any physical therapy at all in the hospital while you were there?
Yes, the nurses, they came in and I had to lay there and they stretched my legs.
Did you receive medications while you were in the hospital for pain?
Yes,
And did you continue to receive medications for pain when you went to Taylor Rehab?
yes,
Were you transferred directly from the medical center to Taylor Rehab?
directly yes,
And you stayed at Taylor Rehab for another week?
yes.
And did they perform physical therapy for that week while you were there?
Absolutely, yes,
And was it helpful?
yes.
And when did the cast ultimately come off?
The cast came off after about 6 weeks or so.
When the cast came off, you were allowed to put some weight on it and then gradually get up to walking over a period of time.
Softly, with the walker.
Since the time that you left Taylor Rehab, who was the first treating healthcare provider that you saw?
As a visiting nurse,
How often would they come to your house?
twice a week.
And how long would they stay when they came?
An hour. They washed me, they cleaned me, they checked me, they took my blood pressure. They just made sure I was okay.
How many times did you follow up with Dr. Marshall?
First he wanted to see me every week, then 2 weeks, and then a month. Then he took the cast off and they cleaned my leg. I came in 3 weeks and then in a month. After that, it was constant follow-up.
An approximation. How many times did you see him since the time you left Taylor Rehab?
Probably 4 times, 5. I don't remember exactly.
And did he offer you physical therapy in his offices?
Yes, he wrote prescriptions for more physical therapy.
And did you undertake physical therapy outside of Taylor Rehab?
Yes, I did.
Where did you go?
Dr. Arthur in Pleasantville.
How often did you go to physical therapy there?
I started, I believe it was twice or 3 times a week to start off. I think twice a week then.
And for how long a period of time did you do it 2 to 3 times a week?
For a few months.
And other than Dr. Marshall and Dr. Arthur and the visiting nurse services, did you see any other treating healthcare providers since the time that you left Taylor Rehab?
No, that was it.
Did there come a time when you no longer needed the walker to walk?
Well, eventually, yeah.
And since the time that you had not used the walker up to the present, have you been able to walk on your own?
Yes.
Do you walk with a limp?
Yes, it hurts. Every step still hurts. Every step.
Is there anything you cannot do today that you used to do before the accident?
Well, I can't jog anymore, which I did 3 miles in the park for 3 miles a few days a week.
Besides jogging, is there anything else?
Yes, I did my home exercise, but I can still do that.
Anything else that you simply, absolutely cannot do?
No.
Let me just ask about the jogging. Before the accident, how often did you used to jog?
3 or 4 days a week after work.
And was that in the summer and in the winter, or would you cut back in the winter?
No, I would run all year if it wasn't snowing out.
Before the accident, when was the last time you jogged?
The day before. I didn't jog because of the weather. It was maybe a few days before.
Presently, is there anything you cannot do like you did before the accident in a lesser degree or something like that as opposed to simply cannot do it all?
Lesser degree? Be on my feet all day long and work.
Anything else?
Yeah, I can't wear my high heels anymore. I can't wear my high heels and look nice, which was important to me. I have to wear sneakers all the time. My footwear I had to change. When I go to the mall with my friends, I can't walk in the mall the way I did. My foot, it gets too swollen.
Other than what we just discussed, is there anything else you can't do today that you used to do before the accident in some degree?
Yeah, I can't do gardening and working with the shovel, pushing with my foot.
At the time of the accident, were you employed?
Yes.
With whom?
I was working for nutrition management.
And what's the name of that company you were working for?
I was working for them at a place called Westchester Gardens.
What were you doing there?
I was supervising 125 units, apartments, recreation areas, garage. I supervised that whole complex in staff and housekeeping.
And was that a full-time job?
Yes.
How many hours a day would you work?
8.
When did you first start working there?
It was September 15th, 2002.
And when did you stop working there?
January, after the accident.
And you never returned after that?
No.
And since the time of the accident until the present, have you undertaken any other employment anywhere else?
Nope.
You haven't worked since the time of the accident?
No, I can't.
Have you incurred any out-of-pocket expenses for any of the care and treatment you received since the time of the accident that was not reimbursed to you from another source?
Well, I'm not covered for medication.
Do you know how much you've spent on medications?
I don't know, a few $100s.
I have no other questions. Thank you very much, ma'am.
After a deposition, whether representing a plaintiff or a defendant, I always ask myself, is the case better now than it was before the deposition? Is the defense stronger now, or were there issues that emerged at the deposition that weakens the defense? These issues should be discussed with your attorney to determine if settling the case is appropriate, or perhaps if your case got stronger, to take the case to trial. I hope this video was informative regarding this next phase of your case, and I'm sure you'll be more knowledgeable, prepared, and comfortable for your deposition. Good luck with your deposition and the remainder of your case. Thanks for watching the deposition.